Good morning. My name is Thomas Reutman. I'm a hearing officer for San Francisco Public Works. Jose Pujol is the clerk for this hearing. This hearing is being recorded and a sign-in sheet is on the table on the side of the room. Please be sure to sign in for our records so that if necessary, we can contact you in the future regarding the item you're here for. The public hearing is being held to consider two items. Order number 200794, a public hearing on the intention of San Francisco Public Works to issue permits for Clear Channel Outdoor to install SFMTA transit shelter kiosks at the following locations: 17TS0011 Palou and Phelps, 18TS0012 Potrero and Mariposa, 18TS0022 887 McAllister, 18TS0023 1391 Haight, 18TS0024 Transit Shelter at 2675 San Bruno, 19TS00006 Fulton and Masonic, 19TS00007 16th and Owens, 19TS00008 eastbound 16th Street at Wisconsin, and 19TS00009 westbound 16th Street at Rhode Island. Our second order will be order number 200884 to consider the notice of violations 9831 through 9850 issued to Walsh Construction regarding the Van Ness Corridor Transit Improvement Project. My job as the hearing officer is to gather the facts for the hearing item, listen to your testimonies, and help our Director of Public Works make determinations. I will not be making any decisions today. Instead, I will forward the findings from this hearing and make my recommendations to the Director. The Director will make the final determinations. When the Director's determinations are made, the Department will notify you of them. Therefore, if you'd like to be notified, please sign in. The hearing will proceed as follows for the two cases. First, I'll ask the Public Works staff to present the case. Then I'll allow the property owner or appellant or applicant to speak. Then any member of the public or witness who would like to speak. And then the department, if the department would like to address any comments, and if needed, from the appellant, again, if there's any rebuttals. Each speaker will have up to 3 minutes to speak. The clerk will monitor the time for all speakers. When you hear the first bell, it means the speaker has 30 seconds left to speak. A louder second bell will signal that the time is up. Due to the nature of the second order comprising multiple NOVs, the appellant will be allowed 30 minutes to respond, and they can choose to break that time up as they see fit to address the various violations. Comments and questions should be addressed to me and not to the department or the applicant. If you cannot finish your comments within the allotted time, you may submit written testimony to me by the end of this hearing. If I feel a question is warranted, I will ask that question. After all the comments are completed, I will close the item. So for order number 200794, may I have Public Works make the presentation?
Good morning. I'm Teresa Muehlbauer with Public Works, Bureau of Street Use and Mapping. Clear Channel Outdoor, in conjunction with San Francisco Municipal Transportation Agency, submitted 9 applications to install new transit shelters in various locations. A transit shelter is a structure for use by transit passengers of the SFMTA that may or may not display advertising. Public Works Order 177159 establishes regulations for issuing permits to install transit shelters and kiosks in the public right-of-way. You can put it up on the screen now. Thank you. Clear Channel is proposing to install transit shelters in the following locations: Palou and Phelps, Potrero and Mariposa, 887 McAllister, 1391 Haight, 2675 San Bruno, Fulton and Masonic, 16th and Owens, eastbound 16th at Wisconsin, and westbound 16th at Rhode Island. Public Works has reviewed the applications per Departmental Order 177159 and determined that it complies with the guidelines set forth. Notifications to all locations were posted on March 14, 2019, complying with the 25-day notice periods. No protests were received. I'm here for any questions you may have. And let me go ahead and show you the locations so you can get an idea of what we're proposing. So this first one is for Paloux and Phelps. And so that's the first picture. This is the second picture. And this is the third picture. I believe for this location, they're also proposing some sidewalk adjustments, which they did give me the legislation for. The second one is for Potrero and Mariposa. Can you see these okay, or you want me to make them bigger?
That's fine, I can see them.
Okay. So these are the locations here. The next location is for 887 McAllister. The next location is 1391 Haight. The next location is 2675 San Bruno. The next location is Fulton and Masonic. The next location is 16th and Owens. Oh, this is 16th in Wisconsin. Let me go back to Owens. Sorry about that. Okay. This is Fulton and Masonic. This is 16th and Owens. The next one is 16th and Wisconsin. This is another one with the new bus bulb out, and we did receive the sidewalk legislation for that as well. All that is in the hearing folder. And this last one is for 16th at Rhode Island. Again, we received information on the new sidewalk legislation about the bus bulb out. All right, and that's what I have to present. Are there any questions?
Were there any written protests or appeals?
No, there was nothing for these.
Okay, thank you. Is there anyone here from the public to comment or protest these?
Yes, this is Gail Stein from the MTA. I manage the transit shelter program. Transit shelters are an important amenity for our ridership. These were all part of transit improvement projects that the MTA is working on or requested by our customers. I'm here to answer any questions you might have, and just want to thank Public Works for reviewing this.
Thank you. Is there anyone else here from the public to comment or protest on any of these transit shelters proposals? Okay, thank you. We'll close this order, and we'll move to order number 200884.
Good morning. My name is Gene Chan from San Francisco Public Works, Infrastructure Construction Management. Again, we're here today for Public Works Hearing Order 200884 to hear notice of violations 9831 through 9850, totaling 20 NOVs. These NOVs are related to the Van Ness Corridor Transit Improvement Project. Work was authorized through an excavation permit issued by Bureau of Street Use and Mapping under 17 EXC 1449. I will be providing some background and context as to what brought us here today before diving into the actual NOVs themselves. So on the project level, the project specifications require Walsh to adhere to applicable laws, codes, safety rules, and regulations. Specifically, the San Francisco Public Works Code Article 2.4, excavations in the public right-of-way, and regulations for working in San Francisco streets, also known as the Blue Book. Many of the NOVs being heard today are covered by 2.4.3. So the department may adopt such orders or regulations as it deems necessary. And also at the bottom there, you can see excavations in the public right-of-way shall conform to the orders, regulations, and rules of the Municipal Transportation Agency. Also, 2.4.83, protection of the excavation and housekeeping. So keeping the area surrounding clean, free of loose dirt in a manner deemed satisfactory to the department. Violation of Article 2.4 or the Blue Book subjects Walsh to administrative penalties. This penalty can be prescribed at up to $1,000 per day per violation. The seriousness, number of violations, persistence, duration, willfulness of the violator's actions is taken into account when assessing the amount of administrative penalty.
I have a little bit of a hearing challenge. If he could keep his voice up, that would be appreciated so I could receive what he's saying. Thank you.
Okay, is there any, can we turn it up or?
I can just move over here and I'll be able to hear better if that's okay.
Okay.
No, it's fine.
Thank you.
The project was issued notice to proceed in October 27, 2016. 2.5 years passed. The project has issued 230 non-compliance notices. These are similar to NOVs, but issued at the project level. And if there are any liquidated damages, it is attached as well. So with the 230 NCNs issued to Walsh, it totaled over $4 million. And it covers housekeeping, safety, and traffic. Today, we have 20 NOVs. There are 34 violations over those 20 NOVs. I have it broken down: path of travel, ramping, crosswalk striping, road plates, housekeeping. These are not new occurrences. There have been NCNs issued in the past from the project, and it relates to those specification sections listed. So regulatory requirements, environmental mitigation measures, traffic control, temporary erosion and sedimentary control, environmental management, and of excavated materials. So again, the issues are ongoing and continue to reoccur. NOVs were issued March 6, 2019. And in March 12th, Walsh issued their written appeal. March 13, they provided corrective actions to 10 of the NOVs, and March 20, they corrected the rest of the NOVs. I'd like to add that our project team does work with Walsh. Our city inspectors communicate with site personnel when issues arise. Additionally, the project team, as a courtesy, maintains a group text message with key personnel from Walsh, wherein city inspectors can notify Walsh of field issues such as path of travel and housekeeping. The reason for this, I believe, Walsh doesn't have the capacity to simultaneously and proactively manage the various working sites along the corridor. The whole thing?
Slower, I just couldn't hear it. You read it pretty quick.
Okay. These issues are ongoing. The city works with Walsh to address issues on a daily basis. Our city inspectors communicate with site personnel when issues arise. We also maintain a group text with Walsh, and that's as a courtesy. We notify them of path of travel issues, housekeeping issues, and it just seems like Walsh does not have the capacity to simultaneously and proactively manage their work site. So I have a few examples of NCNs that we've issued by the project. This is Path to Travel. It was issued September 2018. Path to Travel less than 3 feet, and they abated it, they fixed it. Unique to this process, the NCN on a project level, the contractor is required to correct the action and also propose a preventive action so that it does not happen again. So in all of these cases, Walsh did provide the corrective and preventive action to prevent these issues from, or to try to prevent these issues from happening again. So NCN2, temporary ramps. This was issued July 2018. Again, CNCR. Preventive action was proposed. Temporary striping, CNCR, plates, CNCR, housekeeping, CNCR. And with housekeeping, we also held a meeting with Walsh and some of its subcontractors. This was in June 2018, and we met with Public Works, staff from MTA, Walsh, some subcontractors to go over what is expected, what is required. And so they should have all the information. So now diving into the NOVs. NOV 9831, this was issued and emailed with pictures on the same day, March 6th. Violations was for improper ramping around plate and inadequate path to travel. There's some pictures, tripping hazard from the wedges, the ramping, temporary striping. It was abated on the 6th and also on the 14th with that temporary striping. Here's a copy of the invoice and Walsh's appeal letter. Just to note, Walsh's appeal letters for these 20 NOVs touches on 2 points that are the same throughout all the 20 NOVs. NOV 9832, again, this was issued and emailed with pictures on the same day, March 6th. Violation for graffiti, inadequate path to travel, steel plates improperly stored. So those plates are not ramped. You got graffiti, abated. The plates were ramped, properly placed, graffiti removed. Invoice, as shown, and Walsh's appeal letter. This is a notice of violation 9833, issued an email to Walsh with pictures on the same day, March 6, 2019. Violation for improper ramping around plates, inadequate path of travel. There you can see some pictures. And it's abated March 13. Invoice as shown with Walsh's appeal letter. Notice of violation 9834 issued March 6 and email to Walsh with pictures, violation for inadequate path of travel. So you have tripping hazard, that delineator is there, and it's been abated, holes properly covered, no tripping hazard, properly ramped. Invoice as shown, and Walsh's letter of appeal. Notice of violation 9835, issued an email to Walsh on the same day with pictures, March 6, 2019, violation for inadequate path of travel. This is Filbert to Greenwich, no signage, rerouting the pedestrians, and it was abated, clear path of travel. Invoice as attached, and appeal letter. Notice of violation 9836, issued an email to Walsh with pictures on the same day, March 6, 2019, violation for inadequate path of travel. Here, the plywood does not extend all the way to the barricades, presenting tripping hazard and also potential for cars.
Then again, what's the inadequate path of travel?
The plywood and the barricades. It does not cover that hole. And cars can fall in, people walking by. It's been properly abated, properly covered, delineating work zone, path to travel. Invoice letter as shown, invoice and appeal letter as shown. Notice of violation 9837, issued an email to Walsh on March 6, violation for inadequate path of travel. There you can see upside down detour sign, the concrete curb gutter over there, tripping hazard, it's not properly ramped. Now it's properly abated, over 4 feet, almost 5 feet, path to travel, and properly ramped. Smooth transitions. Invoice and appeal letter attached. Notice of violation 9838, issued an email to Walsh, same day, March 6, violation for housekeeping and site protection. So debris on the job site, and plywood, barricades. Now it's clear, clean. Plywood and barricades are extended to abut each other. Invoice and appeal letter as shown. Notice of violation 9839, issued an email to Walsh, same day, March 6, 2019, violation for site protection and path of travel. So ponding, when it ponds, you have no more path of travel. They abated it, paved it, and temporarily striped it. Invoice and appeal letter as shown. Notice of violation 9840, issued an email to Walsh, March 6, 2019. Violation for site protection and tripping hazard. So the work zone not properly delineated, fencing does not reach the ends. You have a tripping hazard from that open hole for the pavers. It's been abated March 14. Invoice and appeal letter as shown. Notice of violation 9841, issued an email to Walsh March 6 for site protection, tripping hazard, housekeeping. So improper use of the delineators. You have, again, that barricade and plywood, and the pole foundation presents a tripping hazard. Here's housekeeping, loose debris, abated March 13, Claire, barricades and plywood abut each other. The pole foundation has been coned off. Invoice and Walsh's appeal letter as shown. Notice of violation 9842, issued an email to Walsh same day, March 6, 2019, for site protection, tripping hazard, and housekeeping. There's loose debris. It's a tripping hazard, path to travel, and they abated it on the 15th. Invoice and appeal letter as shown. Notice of violation 9843, issued an email to Walsh March 6, 2019 for site protection, tripping hazard. So barricades do not properly close off construction area. You have construction materials on the exposed and abated on the 14th. Invoice and appeal letter as shown. Notice of violation 9844, issued an email to Walsh March 6, 2019 for site protection, tripping hazard. This is a bus stop, so that transition is presenting a tripping hazard, and it was abated on the 20th. Invoice and appeal letter as shown. Notice of violation 9845, issued an email to Walsh March 6, 2019, housekeeping and inadequate sediment erosion control. Stockpiles are exposed, not properly weighted down. They abated it on the 14th, properly covering it, weighting it down. Invoice and appeal letter as shown. Notice of violation 9846, issued an email to Walsh March 6, 2019 for housekeeping and inadequate sediment erosion control. So there you can see stockpile not covered and abated on the 14th. Invoice and appeal letter as shown. Notice of violation 9847, issued an email to Walsh March 6, 2019 for site protection, path to travel. So path to travel less than 4 feet. And abated on the 13th. Path to travel restored, temporary striping. Invoice and appeal letter as shown. Notice of violation 9848, issued an email to Walsh March 6 for housekeeping, inadequate sediment erosion control. Again, stockpiles uncovered and abated on the 20th, covering weighted down. Invoice and appeal letter as shown. Notice of violation 9849, issued an email to Walsh with pictures, March 6, 2019, for improper housekeeping, inadequate sediment erosion control. So there you see again, stockpiles uncovered and abated, this time with straw wattles at the base. Invoice and appeal letter as shown. Notice of violation 9850, issued an email to Walsh, March 6, 2019, housekeeping, loose plates, and site protection. So uncovered stockpiles, tripping hazard from the plate, the ramp. And abated, properly covering stockpiles, straw wattles. Fix the tripping hazard at the loose plates. Invoice and appeal letter as shown. In all the NOVs, Walsh argues in its appeal letter 2 points. It was the first notice of this violation, and the basis for issuance is unclear. As I've mentioned at the beginning, these are not new occurrences. The city project has issued NCNs at a project level since NTP. Secondly, the cited violations and pictures do show the basis of issuance, especially when you look at the before and after pictures. A letter provided by Walsh's attorney also argues the same points. The city responds in the same manner. Additionally, the pictures of the abated violation presented clearly give a contrast comparison that substantiates and supports the issued NOV. The letter continues to argue that Public Works erred in assessing penalties that exceed Public Works Order 178940. I'd like to remind that Public Works Code Article 2.4, which was approved through City Ordinance 33-02, holds a higher precedence than departmental order. As presented at the beginning,
Repeat that slide. I couldn't hear you.
Public Works Code Article 2.4, approved through City Ordinance 3302, I believe holds a higher precedence
That's a higher precedence of what?
than the departmental order. As presented at the beginning, the city can base the penalty on a combination of criteria up to $1,000 per day per violation. Thank you.
Thank you. So we had about 25 minutes from the department, so I'm going to allow, to be fair, the appellant 25 minutes to give your testimony, and we can dive into specific issues. Who's going to be presenting? Are you presenting?
Yes, a couple of points of order. Let me introduce myself for the record. My name is Mike Schoenfeld. I'm an attorney. I represent the appellant Walsh in this matter. A few procedural points of order that I'd like to inquire about as we start. As you communicated in your prepared comments, for individual matters, you give 3 minutes. I got 20 matters to deal with, so I believe I should be given 60. I'd hope not to need that. I just had a recitation just to introduce the violations, no commentary on details behind the curtain. And your introductory remarks identified that you would give me 30, now potentially 25, simply stating that as a matter of due process, which is to give my client an opportunity to be heard in rebuttal, we will be expeditious, but I would request that you yield on strict time constraints unless you believe and share with me that you think we are either repetitious or in any way wasting time. The key for me is simply this. There's over $200,000 associated with these 20 violations. I've got several comments that I wish to make as an introduction, but I have a couple questions because I'm not familiar specifically with the procedures. I went to the codes. I read that both parties were required to submit, mandatory, shall is the word used, communications to the hearing officer as to what they propose to provide. I received nothing, neither has Walsh. My first question is, did the hearing officer receive anything in writing submitted by the department in support of what you've just heard prior to this morning?
Yes, I'm in receipt of the same presentation of this information that was just presented.
My question is, why was Walsh not furnished that?
Well, we're conducting the presentation right now, so you've got the information. And as far as I know, Walsh would have all of these notice of violations received on the
We
date
don't
they
have
were
anything
issued.
regarding the explanation as to what the underlying concerns were. We just have a generic description. Did the hearing officer receive any commentary other than copies of the notices of violation, the transmittal of the email sending it, the appellant letter, and the assessed violations? Did you receive any content other than just the existence of the
No,
material?
I have not.
Thank you. Did the hearing officer receive my April 5th letter with the Walsh letter dated April 4th? It's SFMTA letter 1231. I submitted them on Friday, both to the Department of Public Works and to the designee in the order that established this hearing date, with a request that it be furnished to you.
This is Murphy Austin letterhead?
That is
Yes.
correct.
Yeah, I have those two letters.
Thank you. Thank you.
Just a quick question before you launch into your testimony.
Yes, sir.
Will you be providing all the testimony, or will multiple people be providing testimony?
I believe that I will be calling Mr. Hart as a witness. Is it your policy to swear in witnesses? He's more than happy to be sworn in. I just
No,
don't know
we
what your
don't.
protocol is.
We're just taking testimony.
Thank you. Is it also possible to ask questions of the Department of Public Works based on the representations made, or is it just my commentary and rebuttal, or Mr. Hart's?
No, what I'd like to do is, given the time, and I agree that I said 30 minutes at the beginning, so you guys will have 30 minutes to give your testimony, and I'd like you to use that time as you see fit, giving an overview or diving into specific issues, and the department will have their presentation available to reference should we have to go back to individual cases. But please be mindful of that time, and if we need to engage the department to respond to any of the issues, we'll do so.
Further, I appreciate that. So let me start out by referencing 2.4.81 of the Administrative Code that is applicable to this proceeding. The notice of violation is authorized to be issued, and it expressly requires 72 hours notice from the Department of Public Works, mandatorily, quote, "The director shall notify the responsible party for a violation that he or she has 72 hours to correct or otherwise remedy the violation or be subject to the imposition of administrative penalties." It continues, "The director's notice of violation shall be a written, electronic, or facsimile communication, and shall," again, meaning must or mandatory, "specify the manner in which the violation shall be remedied." You just saw 20 notices of violation. There's an entire section immediately above that which was filled out, which is entitled Notice of Correction. I would ask you, when you look at these, you will see not one of them provided notice to correct, no notice of 72 hours to be given to provide the correction, and lastly, there is not one iota of information that communicates to the party that received them the manner in which the violation shall be remedied. And that's extraordinarily important in this regard. Many of these are so-called path of travel violations. Which way is the path of travel commented on? You saw crosswalks with 6-foot wide steel plates. The path of travel is 4 foot. Is it transverse or is it longitudinal? No communication. And we had more than, Walsh had more than adequate. There's no explanation. What is the violation? You saw many pictures that were taken at 11 in the morning on March 6th in the middle of a shift. I would encourage you to look at the email transmissions. They're at 5, 6, and 7 p.m. after the shift's over on March 6th. The Department of Public Works sat on these perceived notices of violation for 6, 7, or 8 hours before they transmitted them to Walsh. What explanation or justification is that? You've heard nothing that says, during the shift, we communicated to Walsh, hey, we're going to issue a notice of violation unless you get this taken care of. No communications whatsoever were provided. I represent to you, Mr. Hart will say and testify under oath if asked, no such communication was made. What is going on here? The Department of Public Works has now assessed over $200,000 worth of violations. I'll get to the economics later. As to the underlying entitlement, the rules are clear. They have to follow their own published rules. No notice of correction, no 72-hour notice, and no details as to what needs to be corrected, and then they were withheld for many hours after the shift is over without communication. If I was able to put these people under oath who were involved in issuing it, you would hear the following, I believe, under oath by them, that they're on the job site daily, that they interact with Mr. Hart and his staff daily, that they never said a word to him about any of this going on. They never whispered in his ear. You heard comments regarding texts. Well, guess what? Texts aren't permitted by the code as a means of notice, and while texts were, in a group setting, a facilitative manner that was agreed to, the city has stopped using them months ago. They're not viable now. The city is not using them, so please respectfully accept the fact that the representation that they have this group text, well, that's information. It's long behind them. It's not being used, and it wasn't used in this instance, and it's not authorized under 2.4.81A as a means to provide a notice of violation. As to 2.4.81B as in boy, the amount of the administrative penalties, I heard Mr. Chen tell you that a particular provision in 2.4 trumps the rules of the road that we have in this case. I would like to submit to you certain writings issued by the department, including the Department of Public Works in the city, that expressly tells Walsh what the amount of penalties will be should any of these circumstances arise. And you will see they are extraordinarily lower than the $1,000 per day that were automatically addressed. They went to the highest value for every single one. What discretion was exercised? Answer, none. They defaulted to the highest amount. You will see in the materials that I have to share with you the following, and I want to identify them for the record. I have a March 22nd, 2017 letter issued by SFMTA and signed by Hubert Wong as the construction manager, addressed to Walsh that reads, subject, excavation referral. Please find attached city's official transmittal of utility excavation referral number 17 EXC-1449. Attached to it is a May 22nd, 2017 letter from SFMTA to Walsh, again to Mr. Sims, entitled Authorization to Proceed with Excavation, signed by Peter Gabancho, project manager for SFMTA. Please find attached for your review and use a utility excavation referral issued by San Francisco Public Works This referral is in response to Walsh's application, 17 EXC-1449. I believe that is the same authorization that Mr. Chen's comments recited to. And attached to that is the permit, 17 EXC-1449, issued by the Department of Public Works, entitled Utility Excavation Permit. The permittee is Walsh, and the specific wording in the permit, quote, pursuant to Article 2.4 of the Public Works Code, in conjunction with DPW Order 178-940, etc. And it refers expressly to the order that was applicable to this permit. That is one document set that I wish you to receive. Actually, can you hold on, sir? Why don't I give you the second one, which I'm going to refer to now so he can look at it while I'm commenting, please. The second document is the actual order from the Department of Public Works, number 178940, that is expressly referenced in the permit issued to Walsh for this project. And I would ask you to please turn to the next to last page. It bears the page number in the bottom right, number 42. And you will see that this particular order identifies the amount, maximum amount, of penalties that can be assessed for violations. And with specific reference to what brings us here today, the 20 individual items, I would represent to you that my analysis has led to me to conclude that items potentially applicable are items 4, violation of permit conditions, item 5, improper site protection for improper plating, path of travel, barricading, item 7, improper trimming of trench. I don't necessarily know if that's applicable, but it might be. And number 11, improper housekeeping. And you will note that the maximum assessment per day is $500 per occurrence for the first two items, but $100 per block, not $1,000 per violation within a block, $100 per block, such that if the wisdom of the director was to sustain any of these notices of violation, which we strongly believe is inapplicable as an appropriate resolution given the dynamics of the failure to follow their own rules and due process, then the quantification of the violation penalty that is assessed, if any is to be assessed, is substantially lower in light of that which is applicable by the own wording issued by the Department of Public Works when they issued Walsh this permit. There's a concept in the law, and I realize that this is a quasi-judicial proceeding, called ex post facto. Walsh was given notice by the department of the actual violation sanctions, the penalties, that may be applicable to it should it fail to comply, while it disputes its failure to comply with the requirements of 2.4.81, as I've started to comment on. Nevertheless, if the conclusion is otherwise, I represent to you that the contention that 2.4.81b, that the amount of the administrative penalties being a maximum of $1,000, cannot be applied after the fact and should not be applied after the fact. Now, transitioning to the merits, I have another document I'd like you to receive, please. I share with you Notice of Violation 9826. That is not one of the items that's on your agenda today. but I show it to you for illustrative purposes as follows. This was issued to Walsh on this project on February 14th of 2018, 13 and a half months, almost 14 months ago. You will see the top box, notice of correction, was filled out. The individual that did this on behalf of the Department of Public Works followed the responsibilities and guidelines under 2.4.81A, whereas all the NOVs that were received on March 6th, 20 on one day, did not comply. There can be no doubt that the department knows and understands what it's supposed to do pursuant to its own administrative code. Yet it failed without any explanation other than, well, there had been a series of earlier NCNs issued by the owner, in this case SFMTA, and because of that, well, we just decided we're going to disregard issuing the notice opportunity to cure and direction as to what has to be cured. Well, there's no discretion afforded the department to do that in 2.4.81A. In fact, there is an express direction, no discretion shall be exercised. All of the requirements placed on the department are mandatory. They all use the word shall. So the department is intimately aware of what has to be done. It's used this form for at least 13 to 14 months, and yet it inexplicably failed to follow its own guidelines. Now, straying forward, 2.4.81A has 3 exceptions to the 72-hour notice. They're 2.4.81A1, 2, and 3. You heard no testimony, no offers of proof, nothing orally today. And there's nothing in the content of them, the individual notices of violation, that communicate to you that any of those exceptions apply. They don't apply. But you heard no justification for leapfrogging to the issuance of the NOV, ignoring the mandatory requirements, and then assessing the full value, and at the wrong rates on top of it. So I share with you NOV 9826 for 2 reasons. One, to show that it's properly, that the proper methodology was understood, known, and utilized on this project by Department of Public Works, and that you've received no information to explain or justify the conduct, other than another city agency had issued NCNs and we're fed up with it. Well, that discretion is not granted. Now, the response that you received by Mr. Chen to my letter and to Walsh's letter is that these aren't new occurrences, they're repetitious. If they're repetitious, fine. Provide the notice under 2.4.81A that Department of Public Works has given notice. You saw no evidence, not an iota of any evidence that DPW has received any, has communicated their notice to Walsh to correct. And the volume of NCNs that you were shown in a table that just says 23 here or 47 there or whatever quantity, they didn't say that these were the circumstances that were identified here. He said they were similar, but they're not the identical. There was no representation they were, and we know they weren't because Walsh is progressing forward on this project. And so they can't rely on a pre-issued NCN by another agency or department or division of the city to then justify waiving, because there's no provision in 2.4.81A saying that they can sidebar and delete mandatory requirements. So procedurally, these are defective. As I communicated in my letter, and I'd urge you to please read that. No prior notice, 100% no prior notice. Now, we can do this 2 ways regarding what I believe should be additional information. What I'd like to do is to make certain representations that if Mr. Hart were asked questions either under or not under oath, he would testify to, and then get directly to the NOVs themselves so he can explain what he did. Because one of the salient pieces that you're not made aware of because of the representations by the city is that Mr. Hart, Senior Project Manager for Walsh, in charge of all field operations, he gets these NOVs. He directs the crews and they go out and fix them. This was the first onslaught of these NOVs. He didn't know that he needed to get them signed off. And so that's why you see March 13, March 14, and March 20. The record will be from his testimony that they fixed them right away. And what's inexplicable to us is these personnel who signed off on these NOVs on March 13th, March 14th, and March 20th, who daily interact with the people at Walsh, whose offices are immediately next door in the same building, never whispered in their ear, never sent an email, never said a thing. Hey, remember, you got to get us to sign that off so the clock stops ticking on potential penalties. Nothing was told to him. All of a sudden he found out, and then he got these things signed off. But most of these NOVs were actually corrected right away. This was the first time that these Department of Public Works sent an NOV. The other one was signed off on a year earlier before Mr. Hart started on this project. Every single day that's work is going on, the personnel that are involved in issuing these NOVs observe the job, they're inspectors, they interact with Walsh and its subcontractor team. It's interactive, it has to be, that's construction. For the personnel of DPW at 11 a.m., at 10:30 a.m., to take a series of pictures of perceived violations and to say nothing, and then to wait to 5-something, 6-something, or 7-something p.m. to communicate them is not the way business practice or communications or partnering or teamwork approach is made. The pictures showed on March 6th, there was a pretty significant storm going on. You saw a series of NOVs because we have plastic material, visqueen or otherwise, ripped as a result of winds and storm. Was there some debris? Yes, there was. This is construction in the middle of a shift. But for an NOV to be issued in the midst of a shift as a result of a picture taken because of a rip caused by a storm, this is penal. This is not interactive communication, partnering. This is punitive. What is going on? There is no information to Walsh that this was coming down the line, that they better get their act together because there was a perception that they didn't have their act together. Mr. Hart will testify about this conduct. There were no NOVs issued prior to March 6, 2019. Zero, with the exception of the one that was signed off, and it was simply a notice of correction. There were no notices of violation. You will hear the process once Mr. Hart became aware of how these things needed to be corrected. He dispatched personnel or subs to do what needed to be done to get it taken care of. It was taken care of. It gets signed off. He speaks to his contemporary, Hubert Wong, and then the QC managers make sure everything gets taken care of. There is a protocol in place. That protocol was not followed for the NOVs, but that's what's done as to NCNs. This is a daily occurrence. We have many challenges due to issues that are not before you today. And most notably, there's a lot of homeless challenges that impact this project. Several of these NOVs deal with a barrier that's been moved, or visqueen that's been removed, or something that appears out of order. You didn't receive any information as to what it was before March 6th and why it looked like it did on March 6th. The bottom line here is that very selective conduct occurred for the first time on March 6th. Unfortunately, has continued since then, and we may very well have to be back in front of you for another round of these because the pendency of those appeals are going on. The core message is there was no prior notice to Walsh from the Department of Public Works. There was no notice of correction. So I would like to have Mr. Hart talk about the individual ones, and I'd like the ability to use this computer so he could speak to them, so you can get the other side of the coin, if that's okay.
Sure. Before we launch into getting onto the specific violations,
Yes, sir.
I just want to follow up. You've kind of laid a case that until March 6th, you had no prior notice that there was any issues that required correction or
From the Department of
citation.
Public Works, that is correct, sir.
Right.
Yes, sir.
But the department just presented a bunch of examples of NCNs issued prior that were for
I
very
understood those were
similar
issued by
issues.
MTA.
Right, but what he showed based on my cursory review of this is that the same issues are just being reiterated that have been brought up 230 times, not all in whole, they're unique, but there's a lot of reiteration of the same issue. So the fact that it's coming from Public Works or MTA should have shouldn't change the fact that those violations are occurring. So whether the process for issuing or notifying is in concert with Public Works orders is not germane to the fact that the contractor knows these violations are improper and need to be corrected.
If I led you to the perception that Walsh believes it can cavalierly behave in a manner that does not follow rules, I absolutely withdraw that because that was not my intent. My intent was twofold. First, 2.4.81 is a Department of Public Works regulation, which the Department of Public Works is bound to follow. It is the Department of Public Works that issued these NOVs, not SFMTA. And it cannot rely on the shoulders of somebody else, i.e. or e.g. SFMTA, to say, well, they have found housekeeping issues, they have found path of travel issues, et cetera, and therefore we can leapfrog beyond the notice and of correction. There's no authority, there's no provision in the regulation that enables them to do that. I am not in any way dismissing the importance, significance, and merits to any of those earlier issued NOVs, all of which were corrected, but nevertheless, I cannot comment as I stand here and tell you that they were improperly issued or not. I don't know, and I will not make a representation that I don't have comfort making. Do I believe, based on the legacy of this project, that many are disputed? Yes, I know that to be true. But nevertheless, I am certain nobody is perfect. Walsh and its subs aren't perfect. They never will be, but they have to endeavor to be the best they can. That's not why we are here. I am not in any way challenging that Walsh has erred or its subs have erred at various times. They have policies, procedures in place to minimize the risk of that and to repetitiously avoid them from occurring. I know from personal knowledge Mr. Hart, pardon me, is an ass kicker, and he doesn't tolerate improper behavior or not following the rules of the road, et cetera. So the bottom line is, despite best efforts, things happen. Doesn't justify them to happen, it just explains why they may happen. But I am no way contending that the NCNs can be cavalierly disregarded. No. I'm simply saying that SFMTA can't ignore its own mandatory requirements and use that as a justification for its issuance of the NOVs to violate its own obligations and the due process rights that my client is given by the code. If the code is going to be applied, it must be applied equally with equal force. It applies to the department as equal as it applies to Walsh. That's my point.
Thank you.
So, may I-
Before we go into the specifics, I just want to give the department an opportunity to address the assertion that 72-hour notice is required, as that seems to be one of the fundamental issues with the general issuance of these citations.
Gene Chan, San Francisco Public Works. In terms of the 72 hours, section 2.4.83, subparagraph A, section 2, for violations that create an imminent danger to public health, safety, or welfare, or are otherwise subject to section 2.4.73, director shall notify responsible party to immediately remediate violation or be subject to imposition of administrative penalties. So the 72-hour rule does not apply there. And I'm sure they're going to argue that notification was not provided. I'm going to argue that there were 230 NCNs issued previously. I find it hard to believe that Walsh does not know what is wrong or what's going on with the site and the pictures that were issued with the NOVs. Walsh was founded in 1898, incorporated in 1949, 13th largest contractor in the U.S., with 18 regional offices across North America. So as large of a company as that, I find it hard to believe that they don't know what path of travel is, if it was longitudinal, transverse, 4-foot, signage, things like that. They argue that text is not valid, text messages is not valid, and that it hasn't been used in months. I would like to say that that's a not accurate statement, inaccurate statement. Just yesterday, the inspectors and Walsh used a group text message to relay path of travel issues. Blown over or someone pushed over barricades. And, you know, they did fix it, and we are grateful for that. And they question why we applied the maximum amount of $1,000 per day per violation. It goes back to considering one or more of the following: nature of seriousness of the misconduct, the number of violations, persistence of misconduct. I'd like to highlight that, persistence. Length of time over which the misconduct occurred, 2.5 years. Willfulness of the violator's misconduct. This project has been ongoing for 2.5 years. The project is led by SFMTA, but also supported by San Francisco Public Works. As I've mentioned earlier, this is tied to the project. The NCNs were issued by SFMTA for the project. These NOVs were issued under the permit, which was issued to the project. So I believe they're all the same. And if after 230 NCNs you still don't get the point, I think we have a larger problem than this.
Thank you. One other question that was raised about in the reference document with the excavation permit for the amounts being different from the amounts that were on the NOVs. Can you speak to that?
I think it defaults back to the code 2.4. we have the option or the discretion of applying up to $1,000 per day per violation based on the criteria I mentioned earlier.
Thank you. So,
There are two very brief items so we stay on track. First of all, one thing that was not commented on, I don't know that you specifically asked, none of these NOVs, even if you were to find, or the director were to find they were properly issued, which we dispute, not one of them shall specify the manner in which the violation shall be remedied. Whether you can leapfrog over the notice of correction, it is mandatory that each one must identify what the corrective action must be taken to get the NOV or the corrective action signed off. Not one communicate that. That by itself renders each one defective. And when you look at the NOVs themselves, not one cite to communicate or in any way infer that they're relying on an exception set forth, now we hear for the first time in subpart 2 of 2.4.81A, that they don't have to give opportunity to correct because of some imminent threat. What's the imminent threat of plastic that's moved off of a stockpiled material in the middle of a rainstorm? Please look behind the curtain as you evaluate the representation you received and compare it to the content of the alleged violations. It doesn't measure up. Mr. Hart would be the individual I would call to comment on the NOVs.
thank you.
All right, I'd like to add some comments to that. What's the imminent threat to some plastic in the middle of a rainstorm? We have to remember that this is Van Ness Avenue. It is US 101, Caltrans corridor. It's a highway. There are live lanes operating next to the job site. If that plastic blows away, then it can cause a potential traffic accident, traffic collision. It's a high injury corridor. Pedestrians everywhere, bicyclists. So it is imminent danger.
Thank you. I think I'd like to, if given the time, if we can get into a couple of examples so that we can start to go through these issues that you've raised about, not communicating the corrective action. Let's get into that now so we can. What's the time?
So let me just make
So we're already past our allotted time, but we've obviously had some back and forth on this. So I'd like to go to 10:30 on that clock with the NOVs diving in. And I feel like in my review, even though there's 36 or so issues, there's 20 NOVs with multiple violations, but they fall broadly into about 4 or 5 categories. So maybe you can pick the ones that are representative, and we'll just start with those, and if we need to dive in further, we will.
Thank you. So let me just make a representation for the record, and then I'll have Mr. Hart affirm it. He's a senior project manager for Walsh. He's worked more than 30 years in construction, all heavy civil. He's worked 1 year for Walsh Plus on this project, approximately, and most of his time have been involved in projects such as this, urban renovation or new work. He reviews the plans and specs and was well aware of the circumstances and details that bring us here today. His duties include managing all of the operations in the field regarding schedule, subcontractors, Walsh staff. He supervises senior superintendents, assistant project manager, and schedule personnel. He manages all of the daily activities as well as in charge of problem solving the field issues as they arise. He deals daily, hourly, by minute with SFMTA and other representatives of the city. The key person he deals with is Hubert Wong, the resident engineer for the city. When he came to the job, Walsh's practices and procedures that were already in place as to safety, housekeeping, bless you, et cetera. And he would testify, if it was placed under oath, that it was his observation they could do better than they had, and he has steadfastly been involved in making sure they do better. Dan, let me pause for a moment. Is there anything that I just communicated that you wouldn't agree to under oath? And the other representations I made about prior notices since you've been involved with this project, which was about a year, with respect to notices of violation. To the best of your knowledge, has Walsh received any notice of violation from any city agency regarding the issues that bring us here today?
No, not the violations.
Would you speak up?
Not the violations.
Why don't you come over here so the recording can pick you up? Say it again?
Okay, not the violations.
Okay. NCNs have been received?
Yes.
And when NCNs are received, what is your protocol?
We get them out to the appropriate parties to get them fixed,
And you get them signed off by SFMTA staff?
if that's warranted, yes.
And then it goes to the QC side of the world
It
to
does.
get documented?
Yes.
With respect to these NOVs, did you have any prior notice from any individual at SF Department of Public Works that they were concerned or their concerns had risen to such a level that this type of assessment of 20 NOVs on one day was imminent, forthcoming, being considered, anything like that?
I received a phone call, just letting us know there would be
Talk
other.
up.
I received a phone call just to I was let known that there would be additional people on the job site looking at things.
And from whom was that phone call?
From Hubert.
What day was that?
That was the morning of March 6th.
So nothing earlier than March 6th that there was a heightened concern or anything regarding how Walsh was and its subcontractors were acting on the project, is that correct?
That's correct.
Were you given an opportunity before you received any of these 20 NOVs to correct any of these based on a communication? Hey, we're not happy with this or that or anything like that?
Not until we received the violations.
Now, you notice that many of the pictures on these violations are dated, date stamped and time stamped on March 6th as being in the morning. Was there any communication based on your inquiry of your staff and your personal knowledge that any of those items that are depicted were brought to anybody at Walsh's attention earlier than an email that would have been sent enclosing ultimately all 20 notices of violation starting after the day shift was over?
You know,
All right. So let's look at, pardon me, Mr. Chen. I don't want to use the computer and I'm not sure where your materials are. I'm not a computer savvy guy, so if you could get me to your NOVs. Oh, is it just like this? Yeah. Perfect. All right, so, I get it. So, this is a
no, let's go to 9831.
9831. Okay. There we go. So 9831, it's a path of travel.
Yeah, there was two things on here. One was, go back to what's the description?
So the description for this is inadequate ramping around the plate and inadequate path of travel. I'm going to the,
Okay, so when we looked at this picture, we looked at the adequate path of travel. Those are 6-foot wide plates. It appeared to us that they were, there was an adequate path of travel.
pardon me, these are 6 feet wide and this is the path of travel, correct?
Correct.
Do you see any, from your understanding, any violation or any challenge to the ability of the pedestrian within a 4-foot minimum width to travel? Is there any leveling issues or anything there?
No, and that's what, we looked at that as far as a 4-foot path of travel. The plates, yeah, there was some loose cutback. It was raining that night. Had we have been asked, those plates were scheduled that night to be removed, so this was removed within 10 hours of the picture being taken and about 6 hours of when I received the NOV.
So this is pictures taken at 10:22 a.m. You didn't receive this notice until after 5 p.m., correct?
This one I got a couple at about 2, 3 o'clock, and this one was the first one we received.
Pardon me, okay.
Okay.
And the next shift, these plates were actually being scheduled for the night shift to be removed?
Yeah, they were already scheduled to be removed, and that's, part of this is that I see these guys every day, a couple times a day. We talk about this. If that would have been discussed, it was gone within a half a shift.
Okay.
Because they're already scheduled to be done.
So on the evening of March 6th, these were removed?
Yeah, they were.
Okay,
But
pause for a moment. It says it's abated on March 6th and March 14th, so there's an affirmation that you
Okay,
did that.
so that same day on March 6th, we got the NOV signed off at the bottom of it. I didn't realize that both of those had to be signed off. I also didn't realize at the time that the crosswalk stripe needed to be on. We had discussions weeks after this. We were still trying to figure out what the adequate path of travel was. So part of this is because I thought we had to go through this process to come up with an accurate description of what things were.
I would ask the hearing officer to pay particular attention to the form that's up on the screen, but the one you have in front of you will be easier for you to see for 9831. You'll note there are 2 violations identified, and the entire form, not a portion of the form, is acknowledged as being signed off on March 6th. There's no notification to the Walsh that the second one remains outstanding. It is signed off entirely as completed, and there's no notation otherwise. The notice of violation assessment for this particular 9831 indicates $9,000 of assessment, $8,000 for the second one, and $1,000 for the first one, independent of the challenge to the $1,000 versus the $100. The point is, this client of mine was not properly informed, and I note again, when I go to the picture that's up on the screen, what is the path of travel violation that's identified? There's no communication made. That violates DPW's mandatory requirement. This must be properly withdrawn and rescinded because due process and compliance with the mandatory requirements did not occur. Let's go to another one, Dan.
Before we depart from that, just.
Yes, sir.
Because you've
Please-
been.
Please feel free to
So
ask.
essentially, you're saying that Mr. Hart didn't know that he needed to stripe that to make that violation citation.
I was looking at the
Correct.
picture with the plates, and I was looking at what the violation would be for the 4-foot path of travel. The plates were covered, the plates were 6 feet, we've got cut back on the side, the cars were getting over it. I didn't have a clear description of what it was going to take to get the violation signed off.
Okay, but in terms of what the violation was, if I look back about, let's see, 5 or 6 slides from there, can you scroll back?
Scroll backwards.
Yeah. Keep going back to
No.
NCN example 3. Right here.
Temporary striping.
So within this one, which is dated 3/9/2018, it says remarks, no temporary striping in the pedestrian crosswalk. Per spec section, et cetera, the contractor shall use temporary removable tape to demarcate traffic lines for crosswalk. Correct the non-compliance immediately. So if you're telling me that this is the first time on March 6, 2019, that you would have known that you needed to have that striping there, then that's not consistent with this NCN, which was a year prior, that said you needed to do that exact thing.
Okay. At the time when we were looking at the picture, I didn't completely know explicitly what the violation was. We
Okay?
had the plates there, it was raining, there's nothing that would stick or hold that would take care of that. The plates
Okay.
were removed within 6 hours of us receiving that violation.
When you say nothing would stick, can you explain what you're speaking about?
It's wet steel plates. I can't paint it in the rain, I can't put temporary tape, it will not stick in the rain.
Okay.
We had that discussion with MTA as well that day.
All right, let's go to another violation. You want specimen ones. So let's look at 9833 just for a moment.
Look at 9836.
I just want to state, Do you understand that the notice of violation issued for 9833 is simply someone had placed a barricade leaning up against a barricade? That's the violation?
That's the only thing I could see from the picture.
And the assessment for this particular one is $7,000 because it is identified that it wasn't signed off until the 13th. To the best of your knowledge, was that barricade that's leaning up against the barricade removed the moment you became aware of it?
I believe so, but I can't verify that.
All right. And nobody, to the best of your knowledge, communicated words to the effect by email, text, personal conversation, phone call, letter, hey, get rid of that barricade so I don't have to write you up?
Right.
I'm not sure if we're looking at the same thing. You said 9833?
Yes.
So I'm reading the NOV and it's got multiple
I understand.
issues.
If you were to look at the picture in the upper right-hand portion on the screen, you will see part of the NOV is for this identified barricade that I'm pointing to, leaning up against the Bauman landscape permanent barricade, more permanent barricade.
Okay, but the NOV lists specific items that are deficient. There's 4 lines of items.
Oh, I'm simply pointing out an individual component of one of them as I was scrolling through. Is there
Okay.
something here that you want him to talk about? He'd be more than happy to talk about it all.
No, but what you're presenting is only one photograph that has other things shown and depicted in that photograph that directly relate to the NOV as I read it.
Oh.
I need to read it more closely to fully
I understand
understand it.
As I was scrolling through the pictures, I simply was identifying a particular item that I felt was representative of conduct that I think would offend notions of communication, fairness, teamwork, and equity. All right, we're at 9836, Dan, an inadequate path of travel.
Okay, so these are the, we've got in the sidewalk, we have depressions in the concrete to receive pavers at a later date. We built these ramps, the plywood ramps, for the driveways for the vehicles to get in and out. Those had been there for about 4 months, and the adequate path of travel is a sidewalk. So in my mind, I didn't realize that people were walking up and down the driveways. There's bigger than 4 feet, adequate path of travel. All I would ask is just tell me, hey, we need to extend these out. Then it would have been done.
So, Dan, I'm pointing to the upper picture in the upper right. Looking at the garage door out to the edge of the plywood. That's more than 4 feet?
That's 9 feet.
And the path of travel you thought would be from the left side or right side of the picture going the opposite direction,
That is correct.
as contrasted from the driveway out to Van Ness Avenue.
Yeah, the plywood was just there for the driveway access, for the
Was there
cars.
any communication given to Walsh in the 9836 NOV that said the path of travel concerns relate to the area between the barricade and the plywood?
No, it's just inadequate path of travel.
And was the plywood in this picture and all the other ones that are similar, do they extend beyond the edges of the path of travel going straight back and forth by a vehicle?
Yes.
And the city never communicated to you what they were referring to as the path of travel, is that correct?
Correct.
Thank you. What next one would you like to go to?
That's, the rest of them, I mean, you're kind of hearing the story of what we're doing. We took care of these things immediately as they came up. My thought on this is that we talk every day. I wish somebody would have let me know what we were doing, and I would have fixed it. We are doing that actively with all the communications we get, whether it's text, emails, smoke signals. We are actively taking care of the issues we have along Van Ness. It's 2.25 miles. We have a lot of activity, like they indicated, cars, buses, bicycles, pedestrians, things move, things get knocked around. We actively walk this job every day and at night.
Let me just ask you, they said there was a tripping hazard in this picture in 9837. You saw this yourself, correct?
Yeah.
Are the utility boxes flush with the sidewalk?
Yeah, because that's completed work.
Do you know of anything that could conceivably be in violation here? Is it at least 4 feet and there's no tripping hazard?
No.
Okay. I'm going to go to the housekeeping side of the equation. Just to give representative communications. So, let me get a better picture of another one. They're all sort of the same. Here we go. So this NOV is issued on March 6th, 2019. It's number 9845. And there's 3 pictures of visqueen-covered material. Is that in the area that is secured to be used exclusively by the contractor?
Yeah, that's within our work zone.
And do you see anything in the upper left picture that suggests to you, hey, there should be a violation here, we're not protecting the material?
No, again, these are moving sites. I mean, we store dirt, we take dirt away, we cover them. The wind blows, things get moved around, we're actively doing this. I mean, I have a night shift that walks through there and covers them up when they see them.
Do you believe Walsh did anything improper based on your understanding of the rules governing your practices in the work zone with respect to the information that's depicted in these 3 photos?
No, I mean, you always can be better, but housekeeping is one of them. We cover them the best we can.
And the pictures that we see taken regarding housekeeping, they're all taken during active construction periods?
Most of the time.
Okay. Sir, is there, we could be going through each one of these and the representations would be consistent. And I appreciate, for purposes of time, the hearing officer, and no disrespect intended, you've conveyed to us that you get the message that we're trying to communicate, and we appreciate that. We don't want to belabor this. I want to make sure that, to the extent that you have any inquiries or perceptions, that you please ask the person that's most responsible. I'm simply a communicator. This is the person that's living this job, and I would encourage you, if there's any concerns, to please ask.
Okay. Well, I'm just looking at the presentation that the department made, and there's, on housekeeping, there's 78 NCNs issued prior related to, I haven't read each one, obviously, and I will look into those, but they touch on sections of the contract related to regulatory, environmental mitigation, traffic control, temporary erosion, and environmental management. So it's not just a matter of the inconvenience of covering the materials. There's a host of contractual obligations to safety and environmental issues. So if those have been issued 78 times in NCNs, I'm hopeful that through the course of that helps you understand what our requirements are and what our expectations are from the department side. So it shouldn't be the first time that getting an NOV on March 6th is the first time you were aware that this would be a concern to the city.
It's an active site, and there are issues going through there, and we're actively covering everything up that we possibly can.
Okay. As far as the issue of path of travel, maybe the city can speak to this, because I haven't had the luxury of looking through all the NCNs, but I sense that this isn't the first time that these barricades or the tripping hazards adjacent to the plywood and the plates was raised in those. So you're telling me that that issue with the plywood across the driveway was the first time you were aware that you had to fill in the gaps to the barricade? Is
I
that
put
true?
a path of travel across there for a vehicle,
Okay,
for that vehicle to get in and out of that driveway. It's in the furniture strip of the sidewalk. The sidewalk is 16 feet wide. I didn't plywood the whole thing in. I used other barricades, but in my mind, that was for a vehicle. The path of travel is still running north-south down and up and down the sidewalk.
Okay. So has the city, whether it's Public Works or MTA, conveyed the tripping hazard issue of having a gap between the end of the plywood and the barricade, even if it's within that furniture strip?
Not until we got the violation.
Okay, thank you. So have you touched on all of the issues that you want as representative NOVs?
Yeah,
And
yes.
Is it safe to say that of the 20, the 5 issues that we talked about are the same position from Walsh on the others that are similar?
Yes.
Okay, thank you.
I have one last very brief comment. What's behind the curtain, sir, is 20 to 30 more NOVs that have continued to cascade, each of which have been corrected or in the midst of being corrected. There were some issued yesterday in the afternoon. They will be appealed, and so your docket will be filled. We want to stop this. We want to promote communication. We want to promote there to be, we're here to build the job, not here to spend time on administrative matters that don't get the job built. This is not in any way to denigrate the earnestness of the people who are discharging what they perceive as their responsibilities to make sure that the rules of the road, pun intended, are followed. You heard Dan. It's sincere. Walsh has not been in business for 120 years by cavalierly performing work. They respect the integrity and responsibility of being a good citizen. They're not perfect. They strive to be as good as they can be, and when their hand is slapped, it should be slapped, okay. But that's not what brought us here, and that's not what's continuing, and the dynamic needs to be changed. And so my recommendation is that when you dialogue with the director, that you please send the message from Walsh, please direct your people, please act as a team member. Stop defaulting to violations, communicate, share, promote Walsh to be more responsive and responsible if that is the perception. This conduct needs to stop. Having Dan here, and next to him, the other senior project manager, Kelly Burnett, who are the two most senior people responsible for this project, devote time here this morning detracts from getting this job built. That's what's needed. That's what Walsh wants to do. A contractor only is in business to get a job done. There's no value to have it extend. We've had enough challenges that we don't need these, and it is urgently requested because we don't seem to be getting a resonance or an echo. Please change the protocol, communicate, promote responsiveness, and then if Walsh doesn't react as you would expect a responsible, reasonable contractor to do, then default, follow your rules, but try to avoid defaulting to the most severe thing that promotes lawyers and promotes distractions away from getting the job to be built occur. That's a plea that we hope is being heard. It's been requested many times, but we see no change, and it doesn't help the job. Thank you.
Thank you. I'm going to allow the department to respond.
Thank you. Gene Chan, Public Works. I do agree teamwork is needed on this project. Our offices are indeed next to one another. And when we issued the NOVs, they simply came by and asked, what's going on? Our inspectors are sitting right there. They never approached the inspector and asked, hey, what do I do? What do I need to do to fix this? I mean, we're right next door. You're right there. You came into the office. Why didn't you make that extra step? I'd like to also add, path of travel is, these NOVs we're basing it on 4-foot path of travel. But the project, in certain areas, based on the traffic control plans, it may require 5 feet, may require 7, may require 10. So I'd like to ask Walsh to please keep that in mind. And traffic is the number one thing, number one priority. Should be the first thing they set up and the last thing they take down. Should be maintained at all times. Stockpiles needs to be properly covered. And proper meaning it should not be baggy, wrinkly, not weighted down. The project team has already, like to say, gone easy on Walsh. In a lot of pictures, you see that we say that it's been abated, but properly covering stockpiles requires a layer of plastic underneath, a layer covering it, straw wattles around it, and the plastic being weighted down. That's the proper way. So teamwork, yes, it's two-way street. We do communicate with you, with Walsh, field level, management level, executive level. But they need to meet us halfway as well. I think you can see from all the NOVs and the NCNs and the pictures that there is an issue. Please follow the contract and the regulatory requirements. That's what I asked for. Yes, we're here to build a project, but from the city's standpoint, it has to be built safely. Thank you.
Thank you. Yes, I'll be reviewing all the materials that I received today and going through the presentation again. And if required, I will request additional information through the clerk, and we'll let you know if we need more information.
And are those written findings shared?
Those will be presented to the director, and he'll be making his determination.
I understand, but are they shared? Are they public records?
When the determinations are made, they'll be public.
So the underlying conclusions, recommendations, observations, and thoughts that you share with the director are accessible after the fact?
After they've been discussed and the recommendations are made, they will be.
And in the process that is yet to happen, independent of any request for further briefing or comment, is it solely your individual effort and communicating with the director, or are there others involved in the process?
Whatever testimony I've received today, plus the letters that you submitted and the letters that came with the NOVs and whatever background information that's included in this packet will be what's used to make that determination.
I probably asked a poor question. I apologize. You don't communicate with third-party individuals, either within DPW or outside, to ask further questions or communicate. The data that you use is the material that's been presented and that you've received, as you've just identified.
Correct.
That's all I was looking at. It's not a situation where third-party or further involvement or information is obtained.
No, we'll be making an objective review based on what we've heard today.
I apologize. I've not gone through this particular process before, and I just wanted to make sure I understood the protocols. Thank you.
Thank you.
And we'll sign in so that we get copies when they're published? Is that?
Yes.
Thank you.
As a formality, is there anyone from the public here with comment regarding this order? Okay. Again, please sign in if you'd like to be communicated with regarding our findings, and we will close this hearing now. Thank you.